In 2020, the Japanese Financial Services Agency required all regulated exchanges to delist Monero, Zcash, and Dash, classifying them as privacy coins incompatible with anti-money laundering requirements. In 2022, the U.S. Treasury's Office of Foreign Assets Control sanctioned Tornado Cash, an Ethereum-based privacy mixer, making it illegal for U.S. persons to interact with the protocol. In 2023, 2 Tornado Cash developers were arrested and charged with money laundering and sanctions violations. The pattern is unmistakable. Regulators globally are treating financial privacy in crypto as a compliance risk, not a fundamental right. And yet privacy is a foundational property of cash. The US dollar is fully anonymous in physical transactions. The institutional tension is genuine. How do you build compliant crypto infrastructure that also respects the financial privacy principles that underlie the existing monetary system? This video maps the regulatory landscape and the institutional compliance implications. Privacy coins use cryptographic techniques to obscure transaction amounts, sender addresses, and receiver addresses on the blockchain. Monero uses 3 complementary privacy mechanisms: ring signatures, stealth addresses, and confidential transactions. Every Monero transaction mixes the real sender with a ring of decoy senders, making transaction tracing computationally intractable. Zcash uses Zcash proofs, a form of zero-knowledge cryptography, that allows a transaction to be verified as valid without revealing any information about who sent it, who received it, or how much was transferred. Bitcoin and Ethereum are pseudonymous, not anonymous. All transactions are publicly visible on-chain, and blockchain analytics companies like Chainalysis can trace transaction flows with high accuracy. Privacy coins are genuinely anonymous. The cryptographic guarantees are mathematically robust, not merely procedural. The regulatory and market data on privacy coins tells a story of progressive institutional exclusion. Monero's market cap peaked at over $6 billion in late 2021 and has since contracted to under $3 billion, partly due to delistings from major exchanges including Binance, Coinbase, Kraken, and OKX. As of 2026, Monero is available on fewer than a dozen major regulated exchanges globally. Zcash has fared slightly better, maintaining listings on some US regulated exchanges due to its optional privacy model. Users can choose between shielded and transparent transactions. The US Treasury's Tornado Cash sanctions in 2022 represented a significant precedent. For the first time, a regulator sanctioned a smart contract protocol rather than a company or individual, creating new legal frameworks for on-chain privacy tool liability. The IRS has offered bounties of up to $625,000 for contractors who can trace Monero transactions, suggesting that government agencies view Monero's privacy as a genuine investigative challenge. Monero and Zcash represent 2 different privacy architectures with meaningfully different regulatory profiles. Monero's privacy is mandatory and comprehensive. Every transaction is private by default, there is no transparent mode, and no party can selectively disclose transaction details. This absolute privacy makes Monero fundamentally incompatible with AML travel rule requirements, which mandate that financial institutions share sender and receiver information on transactions above specified thresholds. Zcash's privacy is optional. Users can send transparent or shielded transactions. This flexibility means Zcash can comply with AML requirements by using transparent addresses in regulated contexts and shielded addresses for personal transactions. The institutional implication is clear. Zcash's optional privacy model creates a path to regulatory accommodation that Monero's mandatory privacy architecture does not. Institutions that hold, facilitate, or otherwise engage with privacy coins face regulatory risks that are categorically different from other crypto assets. OFAC sanctions risk is primary. The Tornado Cash precedent established that regulators will sanction privacy tools broadly, and any institution that has facilitated privacy coin transactions, even before a sanction, may face retroactive compliance scrutiny. Correspondent banking risk is secondary. Banks providing services to crypto businesses that list or support privacy coins face pressure from banking regulators to terminate those relationships, as seen with Binance banking difficulties in multiple jurisdictions. Third is BSA and AML liability. Financial institutions that touch privacy coin transactions may face Bank Secrecy Act violations if they cannot produce required transaction reporting information. The OFAC sanctions against Tornado Cash in August 2022 produced the most consequential legal case study in crypto privacy regulation. OFAC sanctioned Tornado Cash's smart contract addresses, designating the protocol itself as a specially designated national, making any U.S. person's interaction with it a federal sanctions violation. The legal challenge was immediate and unprecedented. The Foundation for Individual Rights and Expression argued that sanctioning immutable code violates the First Amendment by prohibiting speech. A federal appeals court ruled in November 2024 that immutable smart contract code can constitute property under IEEPA and can therefore be sanctioned, but left open questions about whether deploying or using such code constitutes a sanctions violation. Two Tornado Cash developers, Roman Storm and Roman Semyonov, were charged with money laundering and sanctions violations. The case established that regulatory agencies will pursue both protocol-level sanctions and individual developer criminal liability for privacy tools used to facilitate illicit finance. Institutions building a compliance framework for privacy coin exposure need a four-step risk assessment process. Step 1 is transaction screening. Implement blockchain analytics coverage that screens for any historical interaction with sanctioned privacy protocols or mixer transactions in counterparty wallet histories. Step 2 is listing and custody policy. Establish an explicit policy on whether the institution will list, custody, or facilitate transactions in privacy coins, with documented legal basis for any affirmative decision. Step 3 is AML compliance mapping. Confirm that the travel rule implementation can either satisfy reporting requirements for any privacy coin transactions or that privacy coins are explicitly excluded from the product offering. Step 4 is regulatory monitoring. Track OFAC, FinCEN, and international AML body guidance on privacy coins, which evolves rapidly, to ensure policy remains current. 3 institutional mistakes define poor privacy coin compliance management. First, treating privacy coin delisting as a complete solution. Exchange delistings reduce direct exposure but don't eliminate the risk of indirect exposure through counterparty wallets that previously held privacy coins. Second, assuming that the Tornado Cash precedent only applies to mixers, the regulatory logic extends to any privacy-preserving tool used to obscure transactions from AML reporting requirements. Third, failing to screen for historical privacy coin interactions in wallet onboarding. Counterparties who used Monero or Tornado Cash in the past may be subject to enhanced due diligence requirements under the institution's AML program. The privacy coin debate is a microcosm of the broader tension between financial privacy as a fundamental right and AML compliance as a regulatory obligation. For institutions, the practical lesson is clear. Mandatory privacy tools like Monero are incompatible with current regulatory frameworks. Optional privacy tools like Zcash occupy a gray zone. And the Tornado Cash precedent has established that regulator willingness to target privacy tools directly, including developer liability, is real and expanding. Privacy coins represent one of the highest compliance risk areas in institutional crypto, and the regulatory landscape is tightening. Building the right framework now prevents costly enforcement actions later. Subscribe to Crypto Mechanics for institutional-grade crypto analysis delivered weekly.